mentioned from combined authority.
Yes, good morning.
Good morning, my lords. I'm Mr. Barrett. I appear with Mr. Jackson on behalf of the appellants. My learned friend Mr. Robertson KC appears on behalf of the respondents. Could I start, please, just by dealing with some matters of housekeeping? Could I ask to check that you have the documents we would wish you to have? That's a core bundle,
Yes.
11 tabs, an authorities bundle, 23 tabs, the correspondence bundle, a first unagreed supplemental bundle with 28 tabs, a second unagreed supplemental bundle with 9 tabs, and I hope also on your desk you will have 3 loose authorities. A House of Lords case called G against the London Borough of Barnet, an authority from the appellant about statutory interpretation, and 2 authorities from the respondent, a Court of Appeal case called Lund Poly, which is an old state aid case, and a case called Thomas, which is a recent CAT subsidy judgment.
I'll just check. So there's a core bundle. I've got something headed Appellant's Unagreed Bundle Revised with 28 tabs.
So if I could refer to that, my lord, as the first supplemental bundle.
I was going to say, yes. Is it now agreed?
The position we've reached, my lord, is that my learned friend doesn't object, he says, to me referring to the documents, but he maintains his formal objection. If the court's content in those circumstances, I would propose to deal with the documents in my submissions as necessary. The court, once it's heard the submissions, will be in a good position to form a view as to whether the documents are relevant or not.
And then there's something headed Supplemental Bundle. That's what you're calling the second supplemental.
The second, and the reason for that, my lord, is that certain documents were either missed out of the first bundle in error, or you were given the wrong version of the document. So we tried to correct that with the second document. So I apologise for the fact you've got those 2 bundles. There really should be 1. That's our fault, so sorry about that.
Yes. I mean, this court does expect parties to agree supplemental bundles. The principles are fairly clear. Documents should be included if they're going to be referred to,
Yes.
and not if they're not. But I don't think we're particularly interested in having a debate at this stage as to the rights and wrongs of it.
Indeed, my lord.
Let me just ask Mr. Robertson, what's the position?
The position is, the reason why we didn't agree them is that you're asked to certify that it's necessary for the court to read these in advance.
Yeah. And you didn't think it was?
No, I didn't want to burn.
Do you object to us looking at them? Do you object to Mr. Barrett referring?
If Mr. Barrett's going to refer to them, then you should look at them.
Yes. Yes. Well, in that case, I think we won't say any more. We'll look at the documents, and if anybody wants to take a point on them at any later stage, we'll listen to what anybody wants to say.
Could I just be sure I've got the right ones?
Yes.
Electronically. So the appellant's unagreed bundle, is that 322 pages long?
Yes, my lord.
And the supplemental bundle is 54 pages long?
Yes, my lord, thank you. Thank you. And again, I apologise for the fact you have 2 bundles. It's our responsibility, so I'm sorry about that. Second matter then, my lords.
Since you're making apologies, the authorities bundle, which I was supplied with in hard copy, was overfilled with the result that it broke, as they often do. So
that's a personal apology. That's my responsibility. So I'm sorry about that as well. If it would be helpful, my lord, we will replace that with 2.
it's all right. I've moved it into 2 bundles I happen to have lying around.
Thank you very much. My lord, then you may have noticed in your reading there are some markings on the documents for confidentiality highlighting. Those are markings of the respondent. They assert that those matters remain confidential. We are neutral in respect of that. Therefore, when I refer to those documents in my submissions, I shan't read out any of the material that's highlighted. I will simply ask you to read that to yourself.
Yes, we are being live streamed.
Indeed.
Just to make it clear, it's not because I assert that they're confidential, it's because they have been covered by a confidentiality ring order maintained by the CAT in this case. And so that's the reason that they're confidential. They are our confidential information.
Yes.
But it is subject to a confidentiality ring order that has not been discharged by the CAT and therefore remains in place.
Thank you.
And the timetable, my lord, my other friend and I have had a conversation about that. I asked if I could have 15 minutes extra, given that I will be taking you to the bulk of the documents. He's not happy to agree that. He maintains it should just be equal split, which would mean that I would finish at 2:30 today. I will try my best to finish by 2:30 today, my lord. And it'll be a matter for you, I think. So, my lords, could I just give you the outline structure, please, of my submission today? I'll make some short introductory comments. Second, I will show you the main provisions of the Act and the statutory guidance. Third, I will show you the key contemporaneous documents relating to the decision. And then fourth, I will address the grounds of appeal. I will do that in a slightly different order to the grounds in the appeal bundle and the skeleton. I will take ground 4 first, that's the failure to have regard to the statutory guidance.
Yep.
I'll then deal with grounds 5 and 6, that's failure to apply the policy to which the decision was subject to reference rate communication in a lawful manner. Thirdly, I'll deal with grounds 1 to 3 together. Those are, in summary, the CAT erred in its analytical approach to dealing with the claim for judicial review. And finally, I will deal with failure to have regard to relevant considerations. So, my lords, by way of introduction, as you know, this is an appeal against the order of Mr. Hodge Malik KC, dated the 31st of July 2025. You have the judgment at tab 7 of your core bundle. The tribunal dismissed a claim for judicial review under section 70 of the Subsidy Control Act 2022 against the decision by the respondent to approve the giving of loans totalling in sum up to £140 million, that sum comprising 2 loans, a loan of up to £70.8 million to a special purpose vehicle I will refer to as Trinity, and a loan of up to £69.2 million to another special purpose vehicle I will refer to as Jackson.
Now, the decision is the one in March. That's the one you challenge.
Yes, that's the decision as identified by the tribunal, to be precise, and that's the decision which is before you as part of this appeal.
Yes. The actual lending doesn't take place until November and is not in a sum of 140 million. It's more like 120 million. But what we are concerned with is the decision in principle in March. Is that right?
That's absolutely right. Language of decision in principle, my lord, I would say that's not quite right. I would say it's a good deal more than a decision in principle when you understand the structure of the decision-making process. It really is a final decision subject only to confirmatory due diligence. That's what the documents will show you.
Yes.
But that's the decision that's before you. There's no respondent's notice challenging that that's the correct decision for you to be looking at. So that's the basis of the appeal.
Because we were given a very recent decision,
You were.
CAT, which takes a slightly different view of how decision-making processes fit in with the Act, and we may or may not be hearing an argument about that, and you would object to that.
I would object, my lord. I can't. I'll be perfectly, if I may, blunt about that. I can't deal with that fairly or properly today. It would require proper research to deal with the legal arguments that were made in that case, and it would also require you looking at facts which involve documents that you don't have before you.
So as far as you're concerned, what we are concerned with is the legality of the decision made by the authority on the 22nd of March, 2024.
I say, my lord,
whatever that decision is.
Indeed, I say, my lord, that is, it's not just that's what I say. I say on the correct legal analysis, that is the legally relevant question for the...
But that's what the tribunal thought they were looking at.
That's what they decided they were looking at.
And that's not been...
subject of any respondent's notice.
I see. Well,
fully,
just so I'm clear
of course,
what your position is.
Of course.
Yes.
Fully argued before the tribunal, learned friend not successful on the points he took. No respondent's notice.
Thank you. I won't refer to it as a decision in principle, but as the March decision. Whatever, you will show us what you say was decided.
Of course, whatever's convenient for you, I'll simply refer to it, if I may, as the decision. That's the language I will use. So we respectfully submit that the decision was flawed and unlawful on various public law grounds, and we say that the tribunal's judgment not upholding those grounds was vitiated by material errors of law. I'll develop the detail of that in the course of the grounds, but could I at the outset invite you or ask the court to have regard to 6 factual matters which we say are common ground, or certainly on the evidence and the findings of the tribunal ought to be common ground for the purposes of the appeal. First, neither the decision maker nor any officer involved in this process ever inquired into or considered what pricing and terms would be available to the SPVs on the market from private commercial lenders. Second, one consequence of that failure is that both before the CAT and now this court, there is a significant evidential void or gap on that important question. Thirdly, the only, or certainly best evidence that was before the tribunal or this court to assist in filling that void or gap was evidence provided by the appellant. That is the Maslow loans, which I hope you'll have seen reference to in my skeleton argument. That is evidence in respect of loans of £120 million provided to companies owned and controlled by Mr. Whittaker by a true private sector market lender for developments very similar to those undertaken by the SPVs in this case. They literally are, as it were, around the corner from the developments. Which
well, the developments may be similar.
Yes.
I think it will be said that the financials were very different, the loan to covenant, the cover, and so on and so forth.
It absolutely will, my lord, and I'll deal with that. If I just give you a thumbnail of what I will say, yes, there are points of difference which, as it were, go in that direction. There are also fundamental points of difference which go in the other direction. On the Maslow loans, and this wasn't disputed before the tribunal, common ground, there are cross guarantees against entities of substance, not unbacked SPVs. So what the respondent says is, well, we had some security arrangements, we had a higher proportion of equity up front, better LTV. I should be careful actually. I may dispute that because I say there is a problem with the evidence that was adduced by the respondent in relation to that, and I'll deal with that. But I say what the tribunal hasn't dealt with at all, not disputed before, but the tribunal just hasn't dealt with at all, are what I say are the very important factors going in the other direction.
We, just to be clear about this, an appeal to us from the CAT is limited to an appeal on a point of law.
Yes.
So it's quite difficult at first blush to say, because the tribunal found that the Maslow loans weren't comparable. They weren't very helpful.
That's the finding, with no reasons explaining or justifying that finding.
But on the face of it, that's a factual question of I mean, as you know, the authorities established that the CAT is an unusual, it's not like a court.
Yes.
It's staffed by economically literate judges. It's staffed by economically literate tribunal members,
yes,
who are able to bring their own expertise, yes, to bear. It's quite difficult to say that a conclusion by the tribunal that one loan is not very, yes, comparable to another loan involves an error of law. It looks like a factual conclusion, which may or may not be challengeable, yes, as a matter of fact, but not in this court. Yes.
Well, shall I just give you my
I mean, I'm just...
Of course, I entirely understand, Lord,
yes,
I entirely understand the principle that you're articulating, of course. Lord, the short answer that I give to that is, if you had reasoning from the CAT that dealt with the cross guarantees and explained to you, or explained to my client in some comprehensible fashion why that wasn't a relevant factor, why that didn't point in the other direction from the security arrangements, I would be in grave difficulties. I would entirely accept that. However, that's not what has happened. The CAT has given you a single sentence which refers to 3 points with no explanation or justification and doesn't deal with obviously material points which go in the other direction. And it's obviously going to be a matter for your lordships. But I say, even with the best will in the world and all due deference to expertise, that ought to be something that this court looks at. And
you say that involves an error of law?
Well, the error of law...
I don't want you to take you out of your course, but I'm just trying to identify what the issues, yes, are for us.
Yes. But look, I think, to be frank, I've probably gone as far as I should.
Yes, yes.
Your thumbnail. Could I perhaps... I'll come on to that obviously in the substance of dealing with that, if I may.
Thank you.
Thank you very much. So Maslow loans, we say, under that ground of appeal, but also, well, we say it's a contextual factor, or something that we would ask the tribunal to bear in mind this is the only evidence about how the market prices loans to Mr. Whittaker's owned and controlled companies, and we will say, it is not dealt with in a proper or satisfactory manner by the tribunal. The decision maker, that is the GMC committee comprising the mayor and the councillors of the constituent councils, received no advice as to whether the loans were at market rates.
Sorry, can I just work where you are? You had 6 points.
Of course,
We broke off a bit in the middle of the third one. Where are we now?
Sorry for that, I'm now on fourth.
Fourth, right. So the fourth point is...
Fourth point, decision maker provided with no advice whatsoever on whether the loans were at market rates, therefore did not give any consideration to that issue. Fifth point, neither the decision maker nor any officer gave any consideration at all at any stage to the statutory guidance. We say, my lords, the statutory guidance, we say, is a very important document in this context and area of law. And we say again that just hasn't really been appreciated or grappled with by the tribunal. Sixth point, loans were priced on the basis that would apply under the policies to which the respondent was subject if the UBO, Mr. Whittaker, 1, had provided a full guarantee in respect of the SPVs, and 2, the authority had conducted due diligence that enabled it to understand what Mr. Whittaker's liabilities and creditworthiness were. In fact, common ground, a finding by the tribunal, no due diligence was ever conducted into Mr. Whittaker's liabilities or creditworthiness. And the consequence of that was that the loan, we say, was made on what was obviously an unlawful basis as a matter of public law. We say, in other words, it can't be right that a public authority is making a lending decision about £140 million of public money, or up to, pardon me, £140 million of public money, effectively relying on someone's creditworthiness without having obtained any information about their creditworthiness.
Sorry, I think you said that they were priced on the basis. Can you just say that again, the start of that sentence?
Of course, my lord.
Priced on
the basis that would apply if Mr. Whittaker was giving a full guarantee. I'll show you this in the documents, my lord. I'll show you and explain why I say that.
Right.
So we say, respectfully, my lords, against that backdrop, we say this court should apply close scrutiny to the legal analysis and conclusions of the tribunal. And we say that when that close scrutiny is applied, you will find there are errors of law, serious errors of law in the analytical framework which the tribunal applied. So, my lords know this is the first case under the Act to reach this court. We say that the case does raise a number of points of importance for the operation both of the Act and the statutory guidance at the operational level, as it's applied by public authorities, and also the conduct of subsidy appeals. One point I would make, I hope maybe of interest, just by way of context, paragraph 462 of the impact assessment on the Act estimated that there would be between 50 to 30 subsidy control challenges per annum in the UK. The Act came into force on the 3rd of January 2023, in part. It came fully into effect on the 28th of April 2022. To date, there have only been 7 cases brought under the Act, that's 2 per annum. Had the misfortune to be in 4 of those, always acting for the defendants, with the exception of this case. In all of those cases, the public authority has been successful in the appeal. A number of years into the operation of the Act, there has not yet been a successful claim.
Can I be sure I understand what the consequences are if you're right?
Yes.
The loans were unlawful.
Yes.
What happens?
We're going to have to deal with relief at a further hearing, my lord. So what I don't know if you've seen this, what the tribunal did was to say in the course of submissions, depending on what we find on the different grounds, we can see that the position on arguments regarding relief may be very different. Therefore, I'm not going to hear from you today, either of you, about relief. That will be deferred to a further hearing if necessary. In the event, obviously, it was not necessary given the conclusion reached.
So you would ask us to do the same, just remit it to the CAT to decide what relief follows.
If you were to uphold part of the appeal or all of the appeal, it would seem to me, my lord, that would be the appropriate course.
That I understand entirely, which makes our life easier if we ever get there. What I've not understood is what you're contending the practical consequences should be.
Yes.
Not for us to decide, but just so I have
Yes.
in mind what will happen.
Yes, of course.
If you're right.
Of course. So at the date the appeal was originally heard, my lords, the position was obviously that the loans hadn't, as it were, been given stroke progressed. At that stage, we would have been asking for, obviously, declaratory relief, but we would have been asking for more relief than that. If we were successful, we would have been asking for quashing relief. Obviously, a lot of time has passed and the world has moved on.
The money has been advanced. It's been spent, presumably, on building the buildings.
Presumably, I don't know, my lords, I can't speak to that authority, but one would imagine, yes. To be perfectly frank, I will need, obviously, to take instructions as to what relief at this stage, realistically, we are seeking if we were to reach that stage. And I don't, I'm afraid, have instructions about that today that I can immediately share with you. But that's what will need to happen.
What are the possibilities?
Possibilities, it's the usual menu, my lords. It ranges anything from at one end of the spectrum, relief, at the other end of the spectrum, quashing, and or
Quashing, yeah.
quashing and or in principle recovery orders. So that would be the my client would need to make a decision as to what it's going to seek to press if it were to reach that stage, and secondly, obviously, the court would then be looking at the position and applying the usual principles.
Yes, I'm sure these are very familiar principles to you, but
I'm sorry.
I'm just trying. But suppose you say, okay, it should be quashed. So the position in law is that this loan was these loans
Yes.
were unlawfully made. So
if I say that,
what happens? The
yes.
authority then seeks to recover its money.
So if the court were to,
It can't be left out of pocket.
No, so if the court were to grant that relief, absolutely, as my lord puts to me, the court were to grant a recovery order, that would happen. If I were to be asking for that relief, Mr. Robertson would stand up and he would say it would be hugely prejudicial. I don't want to make Mr. Robertson's submissions for him. He would say it would be hugely prejudicial to good administration, third-party interests for the court to grant that sort of relief. The court absolutely should not grant that sort of relief. If we've lost on the substance, the claimant should have a declaration, but it shouldn't have that other relief because it would be contrary to the public interest. That's what Mr. Robertson, I would anticipate, would say to you or the judge dealing with the matter.
A recovery order is repayment of the loans immediately.
Well, the immediately point, my lord, that there may be, I think that there may well be debate around that in terms of how things are actually implemented as a matter of fact in the real world. But yes, that is at one end of the spectrum. A recovery order is, as it were, the draconian remedy in these cases, if you find that there's been an unlawful subsidy. I should also mention that the appropriate relief also depends on what grounds the claim were not to succeed on. So just to give you an example of that, if the court held, yes, this is a subsidy, unlawful subsidy, in terms of outcome, breach of Section 3, 2, read with Section 12, then, of course, that would take you into the territory of saying, well, we want a recovery order. If, by way of contrast, the claim succeeded on, let's say, failure to have regard to the statutory guidance, the position as to what relief one would be asking for in respect of that probably is different, if you see what I mean.
You might require the authority to go through what you'd say would be a proper process of considering whether it was really a subsidy.
Indeed.
And then one might see where one ended up on that. Yes.
Indeed. I mean, again, if I can deal with it as bluntly as possible, my lord.
You want to get to the stage of establishing...
I would very much like to get to that stage where that's a live and relevant question that I'm making submissions about.
Yes, I understand that entirely. Thank you.
So, my lords, could I ask you then to look at the legislative scheme, the Act and the statutory guidance, and could I deal firstly with the relevant international law and treaty obligations. As my lords know, the Act and statutory guidance give effect to the UK's obligations under the TCA. That was signed on the 30th of December 2020. and entered into force on the 1st of May 2021. Please may I show you Article 366 of the TCA. You'll find that in your authorities bundle at tab 3. Pages 100 and 101.
And just for my understanding, why are we looking at this at all?
Because it's a relevant aid to construction, my lord, and also helps with the purpose of the domestic legislative scheme you're going to be applying.
Are there actually difficulties of construction of the Act?
There may be, my
be.
lords. It would, I think, depend on what you think
Yes.
of the debate and certain submissions. So, Lords, if I could just draw your attention to 2 points, if you have that, page 100 and 101, Article 366. Within subparagraph 1, could I just draw your attention to the language which says that the obligation is to maintain an effective system of subsidy control? I would just respectfully ask you to highlight or note effective system. And then the second point, if you could look at sub 3, could I just draw your attention to the language at the end of sub 3, which states, provided that each party shall ensure that obligations are implemented in its law in such a manner that the legality of an individual subsidy will be determined by the principles. Essentially, domestic law that's used to conduct the exercise.
Which
So that's 3, my lord, just the language at the end
three,
of
yes.
3.
Sorry, what are the principles?
They are the subsidy control principles, my lord.
They're the ones in little 1, are they?
No, it's,
Following principles.
yes, my lord, they are indeed, and they find their expression in the Act, in the schedule to the Act, Schedule 1.
But this is all about when can you grant a subsidy. It's not about what is a subsidy.
Well, I'm just going to explain, my lord, in my respectful submission, it is indeed in my respectful submission, because, my lord, in my respectful submission, establishing an effective system to achieve this objective requires both consideration of whether financial assistance that's been given is a subsidy in the first place, and secondly, if it is a subsidy, consideration of the subsidy control principles. If one does not consider that first question, is the financial assistance a subsidy, by definition, one will miss a significant proportion of the financial assistance being given that is a subsidy. That financial assistance will never be subject to assessment against the principles, and significant numbers of unlawful subsidies will be given. That's why I draw your attention, my lord, to the language an effective system. An effective system of subsidy control requires both. Now, the UK discharges the TCA obligations by the Act and the statutory guidance, and my short point is they are to be construed and applied to ensure an effective system of subsidy control. Now, as to the approach in terms of statutory interpretation of the Act and the relationship between the Act and the statutory guidance and old EU state aid law, could I invite you to turn up my learned friend's trial skeleton, which I say states the position clearly and correctly. You'll find that in the revised unagreed bundle at tab 5.
This is what you're calling Supplemental 101.
Yes, my lord.
Thank you.
My lords have that at tab 5. I could ask you to turn up page 81. And if I could invite the court to read paragraphs 15 to 21 for yourselves. So we would respectfully commend that analysis to the court, and if I could extract two short points that one takes from that. Firstly, no EU state aid law cuckoos in the Domestic Subsidy Act nest. And secondly, in construing the Act, the correct approach is purposive construction, having regard to the provisions of the TCA that I have just shown you. Could I then, my lords, ask you to turn up the Act itself? You'll find that in tab 1 of the authorities bundle. And could I ask you to begin by looking at section 2, please? You'll find that at page 4 within tab 1.
It probably doesn't make any difference at all, since I doubt there's any dispute on it, but when we're looking at the Act and construing the Act, we have regard to the TCA.
Yes.
Is that because the Act tells you to, or was it because of the general principles?
It's ordinary principles of statutory interpretation.
But if you have domestic legislation that's intended to implement a treaty obligation, you have regard to the treaty obligation.
And where there's ambiguity or scope for argument, one seeks to construe it consistently with the treaty obligation where reasonably possible.
And the treaty obligation itself is to be construed in line with not domestic law, but international Vienna Convention.
And Article 4 of the TCA says expressly, you're not looking at EU law. That's the past. That's not what we're doing. We're doing something different now.
Yep.
So, my lords, if you have page 4 within Authorities Bundle tab 1, you'll see section 2, which is the definition of subsidy. If you look at that, please, you'll see that financial assistance granted by a public authority to an enterprise will constitute subsidy where all of the conditions in little a to d are met. It's common ground, as is always in common ground and obvious, that the loans comprise financial assistance and that conditions A, C and D are all necessarily satisfied. The only issue for the respondent in this case was whether or not the loans would confer an economic advantage on each of the SPVs within the meaning of little b. Could I then ask you to look, my lords, at section 3?
I know you say it's common ground. Can you just explain to me why it's common ground but it fits within
of course
1D? It has an effect on competition within the UK, does it?
Yes, it does, my lord. So in a nutshell, that's an extremely low threshold. If one enterprise, i.e. a business, gets an advantage, that's the premise, little b, then that affects its competitive position relative to its competitors. That's sufficient. So that threshold is an extremely...
If it's cheaper for these SPVs to borrow money than it would be for other people, that gives them a competitive advantage. That's how it fits.
In a nutshell, my lord, that's the point.
But then that really doesn't add anything to B, does it?
Adds little in the real world. There are some unusual circumstances where it does add something, but in the real world, certainly with transactions of this sort, it's not going to add
I see. Thank you.
a great deal. So if
This is to do with something within the UK, isn't it?
Yes, it is, and that's the change from the old EU state aid law test, my lord. So it used to be that to fall within EU state aid law, you had to show an impact on cross-border trade.
Yeah, but the TCA, wasn't that to do with cross-border? The bit you just showed us.
No, so the TCA...
I thought the article we looked at was to do with the position as between... with a view to ensuring that subsidies are not granted where they have or could have a material effect or trade or investment between the parties.
Oh, I'm terribly sorry, I haven't understood your point. You're quite right, that's what the treaty says.
Yeah.
Our domestic act has not applied such a cross-border impact on trade test. Our legislature has chosen to adopt a scheme which is concerned with competition intra
or
UK.
Yeah.
I'm sorry,
or cross-border.
Indeed. So, I'm sorry, I didn't follow the point you put to me initially. I'm sorry about that. So, my lords, could you look please at section 3.2 of the Act? This provides that the relevant legal question when applying section 2.1b is whether the terms in which the financial assistance is given are more favourable than, this really is the essence of the test, the terms that might reasonably have been expected to have been available on the market to the enterprise. Could I ask my lords to note 5 short points in relation to the statutory words which Parliament has chosen? First, the statutory question is evaluative. The terms that might reasonably have been expected Second, what is required is a reasonable assessment, not an objectively correct decision. Third, the assessment is directed to what might reasonably have been expected to be available on the market to the particular enterprise. Fourth, the section therefore requires consideration of the particular market in question and the particular characteristics and position of the specific enterprise. Statutory question, in essence, what would the market charge this specific enterprise for the particular financial assistance being provided? I'm sorry, there are 4 points, not 5, forgive me. Should I then ask you to look at section 79 of the Act? You'll find that...
Did you introduce this as the legal test?
This, my lord, I say, is the first stage of applying the legal test. It's an interpretation of the section. This is the part of law when you're construing the...
So I just missed the word.
I'm sorry.
The first part of the legal
test. The legal test, yes. So two stages. I'll come on to deal with this authority, my lord, you're familiar with, you've dealt with in other cases. There are two stages to the exercise. First, one construes the provision. That's a matter for the court, question of law. Secondly, you apply it to the facts. That involves evaluation, judgment. That's for the public body. So if I could ask my lords to look at section 79, which deals with the statutory guidance, just 4 points. I could ask you to note on that. My lords have that, it's page 57 within tab 1, 57 and 58. Two little a provides for the guidance to address the determination of whether financial assistance constitutes a subsidy for the purposes of the Act. For our case. 4, you see there's a requirement for the Secretary of State to publish, keep under review, and he may revise the guidance from time to time. 5, you see the guidance must be consulted on before it's issued. And 6, you see the guidance is a mandatory relevant consideration for public bodies.
When giving a subsidy?
Well, if you look at 2A, my lord, that I showed you, it's not just when you're giving a subsidy, my respectful submission. 2A is specifically catering with the anterior or prior question whether financial assistance constitutes a subsidy for the purposes of the Act. I say the correct construction of 79, reading that language I think you've just looked at in 5 with 2A together, is there can be no doubt that the guidance is authorised to address the anterior question, determination of whether their financial assistance constitutes a subsidy. If that was not the case, my lord, it would essentially denude 2A of effect. 2A needs to apply, and the guidance issued under it needs to apply before one's in a position to decide whether something's a subsidy.
Well, there's maybe a distinction between the provision of the statute defining what the guidance shall cover and the provision of the statute defining what the local authority must do with that guidance.
So I would say, my lord, I entirely follow the point you're putting to me. I would say that would be a very surprising construction. What would be Parliament's purpose in saying that the Secretary of State may issue guidance governing the determination of whether financial assistance constitutes a subsidy, while at the same time saying it's not something that anyone has to have regard to? I would say that would be a puzzling thing for Parliament to be doing. And I say it's not the correct purposive or sensible construction of the words. I say, my lord, and again, I'll be frank if I may, you will find as you work through the Act, you'll find the term subsidy being used not with the precision perhaps that my lords would. Perhaps if I give you one example of that, my lord, the Act defines jurisdiction by reference to subsidy decisions. No one disputes that the Act gives grounds of challenge in relation to something that in the end may not be a subsidy. As I say, if my lords work through the Act, I'm afraid you will find that the word subsidy is not used with the consistency or the precise focus that perhaps you might wish.
Well, I was just looking at section 70, because it's section 70 which confers the jurisdiction on the CAT, and which you presumably invoked.
I do.
Applied to a CAT. And that's someone aggrieved by the making of a subsidy decision.
Precisely.
And a subsidy decision is defined as a decision to give a subsidy.
Precisely.
So do you not need to establish that what the decision in the March decision was a decision to give a subsidy in order to found jurisdiction?
So my respectful submission, not. It's the point I was seeking to explain to the Lord Justice Zacaroli. If I may, jumping slightly ahead, I'll try and deal with it directly, if I may. That provision, my Lord, again, we say sensibly and purposely, and this is how the CAT has in fact construed the provision now in a number of cases, confers jurisdiction to deal with the prior question as to whether financial assistance is or is not a subsidy. That's what the CAT was doing in the present case.
Well, a tribunal obviously has, I was going to say competence. It must have the ability to decide whether something that is brought before it is within jurisdiction or not. But if a tribunal decides that a particular decision doesn't involve the giving of a subsidy, then logically it follows that it has no jurisdiction to review the giving of that decision because it's not a subsidy decision.
That's a question of construction, my Lord, as to what the jurisdiction of the tribunal is. And in my respectful submission, and this is what I'm about to go on to develop in due course, once I've shown you some other provisions, is that the jurisdiction that's conferred on the CAT is to deal with both claims specifically in relation to particular provisions of the Subsidy Control Act, but also general public law claims. And I say, my Lord, again, it would be a very surprising construction if a claimant is entitled to come to the CAT with a claim where it alleges both a breach of a particular provision of the Act and a breach of public law duty. The CAT has the jurisdiction for that claim to be brought before it and hear it, but the claimant could then be told, after going through all of that, we're terribly sorry, you've lost on the subsidy question, so your public law grounds, which were perfectly proper public law grounds, which we were acting absolutely lawfully to hear, necessarily fall away. So that would be.
Well, I think this. I mean, you're now going to develop this at some stage. This may be a significant point because the CAT did say we're using our expertise. Don't think this is a subsidy.
Yes.
It seems on the face of it to follow that your challenge to the March decision fails because if it's not a subsidy, it's not a subsidy decision. If it's not a subsidy decision, you can't complain you're aggrieved by it, however much you can establish that had it been a subsidy decision, the authority didn't.
I entirely follow the point my Lord's putting to me. I have two answers to it. The first answer is I say it's not correct as a matter of construction of the Act. I'll seek to develop that, but I'm giving you the thrust of what the submission is about that. The second point is that's not a point that was taken below or relied on. There's not a respondent's notice in relation to it.
Okay.
My Lords, could I then ask you please to turn up the relevant provisions of the statutory guidance? Please could we start within the authorities bundle, it's tab 22 at page 771. And just before I start with that, could I just also draw your attention to within the judgment, so core bundle, tab 7, paragraph 202, first sentence, the tribunal's finding was that the authority had a duty to have regard to the guidance and to apply it unless there was good reason to depart from it. That's the tribunal's finding, paragraph 202, first sentence.
This guidance is, we've got the 4th edition, dated January 2025.
It is. No material changes on the provisions we're going to look at, my Lord.
Yep.
And you may wish, maybe of interest or not, the Secretary of State's obviously seen what the CAT had to say. His position is as stated in the guidance. There are two simple points, my Lord, that I invite you to take from the guidance. Firstly, the guidance provides that public authorities must give detailed consideration to the section 3.2 question before deciding whether to give the financial assistance. Can I show you please some references for that? Paragraph 1.24, which you will find at page 771, it's within the executive summary. public authorities must establish the financial assistance they're proposing to provide meets the definition. Paragraph 2.1 is within the overview. It is therefore key that public authorities assess whether proposed financial assistance falls under the definition of a subsidy. Paragraph 2.3, the second part of the chapter sets out what public authorities should consider in determining whether the subsidy control regime is engaged. And then the third sentence, the test allows the UK to meet national policy objectives and international obligations. Where each limb is met, the financial assistance will be a subsidy and therefore must be given in accordance with the Act. And that echoes, if I may submit, my Lord, the point that I made to you earlier. That's the purpose of this, that's why this is necessary. 2.13, it's important for those giving financial assistance to be clear and to understand whether to proceed to apply the subsidy control principles as set out in the rest of this guidance. It's a necessary incident, my Lord, necessary incident of acting lawfully. 2.14, some measures straightforward to determine, other instances important to consider carefully. For example, there's a question as to whether the financial assistance is provided on commercial terms. 15.51, for some types of financial assistance, straightforward determination. Yeah, it's page 939.
939.
It is, my Lord. For others, such as a loan, this will be for the public authority to consider. But if we just pause there, my Lords, we do say it is pellucidly clear that this is the requirement that the Secretary of State, exercising his vires, acting entirely lawfully, there's no challenge to his vires, has promulgated. We say this is very important guidance. It's of central importance to the UK's implementation and compliance with its TCA obligations. And we respectfully say that this court, and I'll show you the authority for this, should be taking that seriously and giving it effect. Lords, in the second point in relation to the statutory guidance, it makes detailed provision of how authorities should conduct that required assessment under section 3.2. I'm not going to turn that up, my Lords. If I could just give you the references, it's really paragraphs 15.57 through to 15.81, and that's pages 941 to 946. And you see there are a number of methodologies which are approved for that purpose. Turning back then, my Lords, if I may, to complete the Act, could I ask you to look at section 12? You'll find that behind tab 1 at page 11. And that's the provision that public authorities must consider the principles before deciding to give a subsidy, and must not give a subsidy unless they have formed the view that it would be consistent with the principles. And section 33, which you would find at page 23, which provides that subsidies must be published by public authorities on the centralised, publicly accessible database. So, my Lords, as explained in our skeleton, which you'll find at tab 4, pages 23 to 24, paragraphs 8 to 9, those duties, section 12 and section 33, we say would be significantly denuded of effect if there is not prior consideration by public authorities giving financial assistance as to whether the section 3.2 question is satisfied. If that is not done, the principles will not be applied, the subsidies will not be published on the database, and the efficacy of the remedial scheme of the Act would be significantly undermined. A further specific problem arises, which we say, my Lords, manifested in this case, if that process of consideration is not undertaken at public authority level at the time, as it should be, it creates a situation where a subsequent challenge is conducted in circumstances where there is a void or dearth of contemporaneous evidence in respect of the market. And that leads to a situation in turn where these appeals will need to be conducted on the basis of expert evidence. That is very far removed, in my respectful submission, from a judicial review jurisdiction, which is what the Act, I'll come to show you, tells us this is. So, my Lords, could I then ask you to look at section 70, the provision my Lord put to me? You'll find that at page 51. So, my Lords, that gives the right of action to the tribunal, I entirely accept the point my Lord puts to me. It's in respect of a subsidy decision. Those are the statutory words, and they're defined. I entirely accept that. The jurisdiction that is conferred, my Lords, is not confined to claims for breach of the provisions of the Act. It's a jurisdiction encompassing all public law grounds. Could I ask my Lords to turn up the statutory guidance at page 913 behind tab 22, and you'll see the explanation of that. That's paragraph 13.8 at page 913. If I could ask my Lords to take a moment to read through themselves 13.8, and if you could also perhaps look, you'll see footnote 105 as well. If I could ask you just to read that.
Which other one, sorry?
I'm sorry, Lord, it's 13.8
Yep.
and it's footnote 105. And if I could then seek to just give my response to the point my Lord Justice Nugee put to me. So, Lord, you see there, I say this is a stark example of the point. You can bring a challenge to the CAT to this sort of decision on VRES grounds. I would say, my Lord, it would be surprising, indeed I'd say it would be an illogical and not rational construction of the Act if the position is that claimants are told they can and indeed should, in the interests of effective, efficient case management, bring those claims before the CAT, and then because one limb of the claim in respect of the specific statutory provision in the Act, doesn't succeed, the CAT is denuded of jurisdiction to deal with the public law claim, which was perfectly properly brought before it as a matter of the construction of the Act. And if I could just test that proposition in this way, if that is not so, if the point my Lord puts to me is correct, all it's going to lead to is a proliferation of legal proceedings and the administrative court being faced with additional administrative burdens, because what will happen is you will have your claim, which will be before the CAT, dealing with your public law grounds and your specific statutory complaints under the SCA. You will also, if my Lord's point is correct, need a separate JR, which would need to be stayed before the administrative court. I say that would make no sense. It would serve no useful purpose.
What's the relevance of error of law as a public law ground here? So section 2 you showed us defines as a matter of law what a subsidy is.
Yes.
If someone wishes to complain about
Yes.
a decision, if the complaint is that, for example, it wasn't given directly or indirectly from public resources, condition A.
Question of law, objective question for the court on that limb, in my respectful submission.
On 1A.
On 1A. They're all objective questions of law in my respectful submission, save for the section 3.2 question. The section 3.2 question in my respectful submission is an entirely different question and test. The submissions I sought to make to you about it, my Lord, section 3.2 is raising matters of fact and evaluation, not a hard-edged question of law. That, under our constitutional principles, public law principles, is for the authority, subject to the court's review on rationality principles. I'll seek to show you high authority that explains that. And perhaps actually that takes me to the next point, actually, in fact, my Lord, because section 75...
3.2 is part of his elucidation of 2.1b, isn't it?
It's telling you what 2.1
So 2.1b, you
means.
accept, is a... Is this right? That's a hard-edged question.
It's not, my Lord, because you have to read it together with section 3.2. So they are inextricably intertwined. 3.2 is telling us what advantage means within 2, and 3.2 is telling us that there is a test of fact and evaluation. And as I say, as a matter of the correct construction of the Act, I say that's not an objective question for a judge. That's a question for the authority in the first instance, subject to the court reviewing on rationality grounds. both for reasons of constitutional principle, but also for reasons of good common sense, to put it bluntly. In the first instance, it's, in my respectful submission, appropriate that it should be the public authorities, the people who are tasked with this stuff, who are actually in the relevant market potentially, who are making the first level decision. And that decision on these sort of matters should only be disturbed if they exceed the, and I don't dispute, the generous margin of appreciation they get in making those judgments.
That I can understand that in the sense that, I mean, it is a question of law, nevertheless, isn't it? It's just one which admits of a range of possible answers.
So there are different ways of analysing my respectful submission, my lord. Some cases do it in precisely that way. Some simply speak of rationality. I mean, the judgment which my lord, I think, knows well, I believe you had detailed submissions about it in the Bulb case. Sort of the classic authority is the MMC case, the House of Lords decision, Lord Mustill. The way he puts it is, it's a two-stage process. Stage one is a question about construing what does the Act mean. That's for the court. So the language in MC is substantial part of the United Kingdom. Construing, that's a question for the court, but it's then got to be applied in the world. The judgment as to how that's to be applied in the world, once the court has construed it, is for the public body, and their decisions in doing that are subject to review by the court on rationality grounds. So I will show you that, my lords, but that's the...
So what I was going to say was I understand that point entirely. Yes. If the decision maker's made a decision which is not a binary legal question, but involves a range of possible answers, then respect is given to the decision maker, and it can only be challenged on grounds of irrationality.
Yes.
Although it's probably still an error of law challenge.
Yes, absolutely, in the end.
But this case may raise a slightly different question, is if the public authority doesn't make the decision at all, it just assumes that it's a subsidy.
Yes.
What's the role of the reviewing tribunal then? Because there is no decision to give respect to.
So I entirely accept what you've just put to me as entirely factually accurate. The answer to that question, my lord, and this is jumping ahead, but the answer to that question is, the question is there any public law obligation to consider the thing in the first place? And the reason I've been showing you the statutory guidance is because in my respectful submission, the statutory guidance, beyond doubt in my respectful submission, imposes such a public law obligation. That's exactly what the statutory guidance is there to do. I'm going to show you the House of Lords authority that says it imposes public law obligations and you've got to comply with it and so on and so forth. So, my lords, could I ask you to look, and this is picking up the question, sorry, I think my Lord Justice Nugee, I think, was, pardon me, actually, Lord Justice Miles, about the principles. If you look at sub 5 within 70, you will see that that's a statutory provision which tells us what the tribunal's jurisdiction and role is. It's applying judicial review principles. Judicial review court. And those are domestic judicial review principles. So, and this I think is picking up on a number of the questions you're putting to me. Could I, having shown you those provisions, distill what I say the relevant legal framework here is? Firstly, the decision maker is subject to a public law duty to consider the Section 3.2 test before deciding whether to give the financial assistance. I say that's pursuant both to the statutory guidance, the provisions I've shown you, and also as a matter of implication, looking at Section 12 and reading it with Section 3.2. Again, I'll develop this and make this good. But even if the Act didn't provide that, the statutory guidance certainly does, and that imposes a public law obligation. Secondly, the decision maker...
Sorry, you say... Sorry, that's quite quick.
Sorry.
Sorry, can you say that again? So, are you saying there are two sources? There's section...
Yes, I'm saying there are two
79.6, is that right? Which is a specific... Yes. You say that's a specific statutory obligation.
I do, and perhaps more, so there's no confusion, I'll give you my full submission now against jumping ahead. There are actually three sources at issue in this case. Firstly, there's a statutory guidance. Secondly, there is, I say, the correct construction of the Act, reading 3.2 with 12. Thirdly, under the policies which the authority is subject to in this particular case, there was also a public law obligation under those policies to think about these issues, and again, I will show you these. So I say there are three, in fact there are three sources, and I don't think the tribunal disagreed with that. The error happens at a later stage. So the second point, I do need to make sure you've got this, my lord, this outline. The second point, the decision maker is required to have regard to the statutory guidance when conducting that consideration. The third point is a challenge to a decision alleging that the giving of financial assistance has given rise to a subsidy, section 3.2, is determined on orthodox domestic public law principles. Tribunal's task is to review the decision based on the material before the decision maker when the decision was made.
I'm sorry, I missed your second point. So the first one is you're under a duty.
Yeah, so duty, my lord, for those three reasons I briefly explained. Secondly, decision maker required to have regard to the statutory guidance when considering whether the financial assistance does or does not meet the section 3.2 test. Thirdly, a challenge to a decision alleging that financial assistance does give rise to subsidy is determined on domestic public law principles. That entails the tribunal reviewing the decision based on the material that was before the decision maker when the decision was made. That's how our public law works. Fourth point, insofar as a public authority, in defence of such a claim, wishes to rely on evidence that was not before the decision maker, either predating or postdating the decision, the public authority has the ability to advance that evidence pursuant to a no substantial difference analysis. And that's to pursuant to section 31(2)(a) of the Senior Courts Act 1981. Very common ground in judicial review.
This is the one that says even if technically you didn't comply with your duties.
If you've made a mistake, if there is clear evidence that the mistake didn't make a difference, couldn't make a difference, no relief.
And the importation of the judicial review principles in section 75 brings in that principle.
Absolutely, absolutely. So it's not bring in. In my respect, submission law, it's not so much bring in, it's establishing that is the jurisdiction. The jurisdiction is this judicial review jurisdiction. That's what section 70 is doing.
Yes.
Just give me the section number.
Of course, my lord, it's section 31, subsection 2A, Senior Courts Act 1981.
But it's now, I think, a positive obligation on the administrative court not to grant relief if it wouldn't make a difference.
If it considers that test is met.
Yes.
So the argument was not run below. There is no respondent's notice.
Yes.
But that's where the special law, I'm jumping ahead, that's where, well, we thought about something later or someone else thought about something, that's where it fits in the relevant analytical framework. And the tribunal's unawareness of that, in my respect to submission, we'll see leads it to make some errors.
Can I just understand that?
Of course.
Right, I know you're going to develop it, but just say I understand the issues. Suppose that you establish that the public authority here did not consider
Yes.
the question you say it had to,
Yes.
which is section 3.2.
Yes.
But as a matter of the CAT's decision, the CAT has decided, well, it wouldn't have made any difference if the
Yes.
public authority had gone
Yes.
through that exercise, because it's not in fact a subsidy.
Yes.
Do you accept that that's an answer?
It would, so if the CAT had done the analysis properly, my lord, applied the relevant statutory test and reached that conclusion, that would be a full answer to my case. It's part of my case that because of the confusion on the part of the tribunal as to the applicable legal framework, it hasn't actually ever asked that question, this question that the legislation requires us to ask and answer under section 31. What it's done essentially is take a shortcut, and that, I say, leads it to make some errors in law and to distort the applicable legal scheme. That's my core submissions to you. I'll seek to develop that and make that good. So, my lord, we
Would
say...
it be, sorry.
Of course, sorry, I'm sorry.
But would it be open to this court to say, okay, it didn't go through that
Yes.
mental process, but on the CAT's findings,
Yes.
it would not have made
Yes.
any difference?
So I would respectfully submit not, my lord, and that's because the CAT has never actually asked the correct legal question. It hasn't applied the specific test that arises under section 31. As I say, it's taken an intellectual shortcut, and I say a misturn. And so I say one can't properly or safely reach that conclusion because of the circumstances where the CAT hasn't actually applied the right test. one doesn't know what the result of the right test would be. The CAT's applied the wrong test, in my respectful submission.
Is there another way of looking at this, or
Yes.
looking at error of law approach, which is that if the CAT's conclusion that this was not a subsidy
Yes.
shows there was in fact no error of law, because the decision maker, whatever considerations and guidance the decision maker didn't follow, reached the right conclusion.
So again, I think my answer to that is that the CAT's decision about that question, in my respectful submission, is vitiated by the errors of law which preceded the failure to apply the correct legal framework and tests. So
Whose error of law?
the CAT's errors of law,
Right.
and the principles they're applying. So my answer to that, my lord, is if they had got the law right on those prior questions, then we might be in that territory. But when they've made, in my submission, material errors of law, no, I say it leads to a classic case where the decision that has been made needs to be overturned. So, my lord, we say, drawing those 4 points together, that applying that framework produces, we say, an effective, principled, coherent and balanced legislative and regulatory scheme of subsidy control regulation, which effectively implements the UK's obligations under the TCA and appropriately respects the legislative and regulatory scheme established by the Act and the statutory guidance. Lords, could I then just take you quickly through...
Sorry, what do you say the error of law was then, that vitiates, on that last question?
On the CAT's approach? So there are a number of interrelated points, my lord, but the nub of the point is the CAT did not, in my submission, ever judicially review correctly in law the decision that was subject to challenge. I'll seek to show you this. I'll obviously take you through the judgment. They were looking at all sorts of things, all sorts of evidence, which is, under the applicable legal framework, not admissible. I think to answer that question well, my lord, I will need to develop that. I'll need to take you through the material. So, my lord, on the facts, if I may, I think, need to speed up. I'm sorry. Obviously, you're aware the authority, statutory public body, decision-making body comprised the mayor and its constituents, councils, representatives. That's judgment, paragraph 4, core 7, page 71. The SPVs, which receive the loans, are ultimately beneficially owned and controlled by Mr. Whitaker, a significant property developer in Manchester. Point of factual detail, my lord, just to try and avoid confusion when you go through the judgment. There is no Renaker corporate group. You'll see corporate group, that language used in the judgment. The factual position is essentially that Mr. Whitaker owns disparate SPVs, but there is no consolidated group structure. There's some basic information about his operations, paragraphs 2 and 3, but you will not get that point. So just to try and avoid confusion on that as you read the judgment, no corporate group. The authority in this case was administering the Greater Manchester Housing Investment Loan Fund. I'll just refer to that as the fund. And that comprises funding provided by central government pursuant to a facility agreement. You'll see that described in the judgment at paragraphs 63 and paragraph 70. The facility agreement requires, my lord, and this is set out in those paragraphs, that loans under the fund are priced at market rates and at a minimum rate which meets the provisions of the state aid communication, that's the EU Commission reference rate communication. The facility agreement also provides that the distribution of the proceeds of the lending will be divided between central government and the authority based on the rate which is derived from the reference rate communication. So it's an obligation as to what the authority must do, and it's also the framework for the division of the spoils, if I can put it in those terms. At the date of the decision, the capacity of the fund was £300 million. The decision entailed lending half, or approximately half, of the entire capacity of the fund to one UBO via two SPVs in a single transaction. Could I ask you quickly to turn up the authority's own applicable policy, which is an investment strategy? You'll find that in the unagreed bundle, first unagreed bundle, behind tab 21, at page 269.
I'm sorry about this, but may I just ask you a prior question?
Of course.
Before we go to that? Is the point about the commercial terms in the facility agreement in the CAT's decision?
I think so. I think it's, I'm sorry if I'm giving the wrong reference, but I think it's 63 and 70. Let me just check that.
Yeah. 63 and...
I thought 70, but I'm going to give you a bad reference. Yes, so 70,
yeah,
and 63.
So that deals with at least the state aid reference rate.
It does.
But I think you just told us there's something about commercial.
I did know, so that's what I'm taking from 63, which is telling you a minimum, a risk margin then applied on top. So that, my lord, as I understand it, and I think this is also how the authority understands it, what that's saying is this is all on market terms. This is not a subsidy arrangement. It's not intended to be a subsidy arrangement. It's intended to be section 3.2 compliant, if I can put it in those broad terms.
We don't have the facility agreement as
We
such.
don't, we can certainly get it for you if it would be of assistance.
But it just, one question that might arise out of that is that those making decisions on behalf of the public authority
Yes.
knew that they had to do so on commercial terms.
Yes. So
So was that not a background
yes. So
fact
of course.
that those people must be taken to have been aware of?
Yes, so can I give you three answers, my lord? So firstly, I would respectfully submit not. This is a matter actually of some specific detail, and my respectful submission, one couldn't assume that all of the 10 councillors on the committee do know that unless they've been briefed about it. So that would be my first answer. My second answer would be, my lord, even if they know that fact, the essence of my submission is that knowing that fact would not be sufficient. One would need some advice as to how or why this particular transaction complies with the relevant standard. But of course, I follow the point my lord puts to me. So, my lords,
Yeah.
could you look at paragraph 7.2 of the policy? You find that at page 269. And it's the language beginning, the pricing of all the loans will be risk-based. If I could ask you to emphasise this language, following an assessment of the borrower's financial covenant. And if I could ask you to emphasise borrower. And then you see the minimum rate determined applying the communication. That's the authority's own policy to which it's subject. So two obligations, my lords, there's the contractual obligation flowing from the facility agreement, and then there's the public law obligation flowing from the policy. 2 points about that, so probably three points about that, if I may. Firstly, risk-based, what's required, the obligation, risk-based pricing based on assessment of the borrower's financial covenant, not an assessment of someone else's financial covenant, the borrower's financial covenant. Secondly, at this point, pardon me, it's both a requirement of the facility agreement and the policy. And we say, flowing from that, my lords, there was a public law obligation on the authority to have regard to these considerations when making the decision. Could I then show you the communication itself? You'll find that in the second unagreed bundle behind tab 1. And I think the lords will be well familiar by this. It's the EU level methodology to calculate proxy interest rates for public authority lending. On the first page, we see that the two key points made are that the determination of the applicable interest rate must be based on the debtor's creditworthiness and collaterals of the debtor who must be assessed. And we see that a key requirement of the design of the measure is that the methodology is simple to implement. Second page, we see that the Commission considered in detail other possible methodologies, but they were rejected because it was not desirable to have complexity or uncertainty. We see that the current methodology was specifically chosen because it's simple, clear to apply, and ensures consistency. On page 3, we see the mechanism itself. As you know, it provides for the establishment of an applicable interest rate by having regard to two components, base and margin. Base determined from time to time by the EU Commission. No dispute, the base was 5.65 at all relevant times. for the life of this case. Margin determined applying the matrix on page 3. The matrix allocates the margin based on, firstly, the creditworthiness of the borrower, and secondly, the level of collateral being provided for the loan. 2 factors.
Where are you reading from there?
I'm sorry, Lord, it's the matrix. I'm asking you to look at the matrix itself, the table.
It's page 4.
Page 4, Lord, I'm sorry. Page 4. And those are the 2 constituent elements. Looking at the matrix, you see if the borrower's credit rating is below B, but they provide high collateralization, essentially the best security package possible, the required margin is at least 400 basis points, that's 4%. And you will also then see that that effect of the matrix is narrated in some of the text that follows on page 4. Borrowers that do not have a credit history or rating at least 400 basis points, depending on the available collaterals, and we're obviously going to come back to that in the course of dealing with the grounds. Those are the key documents governing the decision-making exercise. Pre-decision then, my lords, just two parts or 2 points I need to deal with in relation to that. Firstly, the starting point of the process is direct negotiation between the respondent's chief investment officer, Mr. Bill Innovoldson, and Mr. Whittaker at 2 unminuted meetings. Could I just correct a point in the judgment? I think there may have been some confusion on the part of the tribunal. If you could turn up the judgment at page 87 at paragraph 76, at the final sentence, you'll see that the tribunal incorrectly describes Mr. Innovoldson as a transaction manager. That's not correct. That's the most junior level of the respondent staff dealing with these matters. Mr. Innovoldson was the chief investment officer. That is Miss Blakey and Mr. Walmsley's boss. The tribunal's confusion may have arisen because there is no witness statement from Mr. Innovoldson. There is no reference to Mr. Innovoldson and Miss Blakey or Mr. Walmsley's witness statements. And other than the 2 emails that I'm going to ask you to look at, you don't have any documents relating to Mr. Innovoldson. I do think of him as Banco's ghost in this case, without intending any discourtesy to him. Can I ask you to turn up those 2 emails? The first one is in the supplemental bundle behind tab 7, tab 2, pardon me, at page 7. Its content can't be found in the supplemental bundle, second supplemental bundle, tab 2, page 7. And its content can't be found in the judgment. What you see is Mr. Innovoldson reporting that he's been negotiating with Mr. Whittaker, and quote, he wants to agree the pricing and terms beforehand, if we can. We can pick up on this tomorrow if you have time. So Mr. Whittaker's strategy is to agree the pricing before there's engagement with the governance process. There is no witness evidence explaining what was done or what happened in relation to that. What you have then is the second email, which is on the 13th of February. There's a further unminuted meeting between Mr. Innovoldson and Mr. Whittaker. And the email that's been disclosed by the respondent is at unagreed bundle, the first unagreed bundle, tab 22, page 271. And you'll see there is an email from Mr. Innovoldson to Mr. Whittaker, where he says, I think we agreed the following. I won't read out the figures because they may be said to be confidential. The following redacted margin for D1, reducing to redacted.
Sorry, where do we find, I think we've agreed?
So tab 27, tab 22, my lord, page 271.
Yes.
And if you look, it's around the middle of the page. So that it's Mr. Innovoldson firstly writing to Mr. Whittaker after their face-to-face negotiation. He says, I think we agreed. Do you see that language?
Oh yes, I think we agreed.
I'm sorry, my lord.
About 5 lines up.
Yes,
lines
I'm
up.
sorry.
I think we agreed the following.
Yes, I shan't get the figures in case they're confidential.
Well, they're in the judgment.
I think this email is, my lord. The first email isn't, but this email.
But these figures are in the judgment.
They are. I'm sorry, you're quite right. Forgive me. Some of the
Paragraph
other
75. So
the breakdown isn't, I think,
All right.
but the global figure. You're quite right. Forgive me. But Mr. Whittaker then, if my lord reads up the chain, we agree to your understanding of what we agreed. So, my lord, That is when the rate was set in the real world. That is when the rate was set. It's recording on its face an agreement between Mr. Enevoldsen, the senior fellow, and Mr. Whittaker, the senior fellow, in relation to the interest rates that would subsequently be given effect in the loans. Those are the rates which were subsequently given effect in the loans. And what you will find, my respectful submission is, following that agreement, because of that agreement, they weren't really seriously or properly considered, because two senior chaps had sat in the room and reached an agreement. Exactly what Mr. Whittaker had wanted to happen. So the second part of the pre-decision, then, my lords, is just two internal advisory panels. There is a meeting of the Respondent's Gateway panel. That's on the 22nd of February. And there's also a meeting of its Credit Committee on the 7th of March 2025. The material points for my case, firstly, those are not decision-making bodies, that's common ground. Secondly, the minutes of those meetings show that there was no consideration of the pricing or terms of the loans. Can I just give you the references for that, please? It's First Unagreed Bundle, tab 23, page 273 for the Gateway Committee, and Unagreed Bundle, tab 24, page 276 for the Credit Committee. There's no witness evidence from any of the independent members of those panels, and there is no witness evidence disputing the accuracy of the minutes. That takes us to the decision, my lords. That's the 22nd of March. The decision is one of the GMC committee, comprising the mayor and the representative councillors. Judgment holds that is indeed the proper decision subject to challenge. See paragraph 15, final sentence at page 131. The public party report states on its face that the decision relates to a major strategic decision as set out in the GMCA constitution. You see that within the report. It's core bundle, tab 11, page 177. But provided no further relevant information. The private Part B report, which is behind tab 11 in the core bundle at page 182, recorded the interest rates that would apply to the loans, those being the rates agreed between Mr. Enevoldsen and Mr. Whittaker. Just to explain to my lords, the numbers may look different to you because you'll see that 1% has been split out and described as a loan management fee. So I hope that's not confusing. The figures are the same, it's just they're being represented in a different way. My lords, in relation to the meeting, the basic points we make are there was no reference or advice in relation to the statutory guidance. There was no consideration of whether or not the pricing and terms were consistent with what the SPVs could obtain from the market. And there was no advice and consideration as to whether the rates and terms complied with the facility agreement and the investment policy. Those are the short points.
Sorry, I hadn't picked up the point about the loan management fee. So that's per year, 1% per year, is it?
That is most. That's part of the 3% figures that you saw Mr. Enevoldsen agree with Mr. Whittaker. It's just been split out for the purposes of that report.
There's not a one-off fee. There's an arrangement fee, which is a one-off fee.
That's a separate.
That's a separate thing.
Separate point, Lord.
So this is an annual.
It is, Lord. The short point again, it's not in dispute. The rates which are applied in the loans are the rates that Mr. Whittaker and Mr. Enevoldsen negotiate. There's no dispute about that. Whatever that does or doesn't mean legally. Could I then just ask you to note the notice of the decision? That's in the supplemental bundle, the second supplemental bundle behind tab 3 at page 20. That provided that the loans were approved and that, quote, authority would be delegated to the Treasurer in consultation with the Solicitor and Monitoring Officer to prepare and effect necessary legal agreements. So, my Lord, you put a point to me at the start, what was the sort of proper characterisation of the decision? As my Lord will know well, there are all sorts of different possible approaches. This is, in my respectful submission, a very hard decision. What's delegated and all that's delegated is essentially getting the thing signed up and executed. That's what was done in this particular case. Post-decision, then, my lords, on the 15th of April, my client sent a pre-action letter to the respondent about the loans. I'm not going to ask you to turn that up. The reference is second supplemental bundle, tab 4, page 24. And for present purposes, the material point is that the letter asked the respondent to provide the written records of its consideration of compliance with at section 3.2. At 16:58 on Friday the 19th of April, that's 4 days later, Mr. Walmsley, a junior officer of the respondent, sat down and began drafting up what I will refer to as the Walmsley paper, and that in substance is a justification defence of the lawfulness of the rates which have been applied on the loans. We will look at the paper, my lords, in the course of dealing with the grounds in some detail. Could I just ask you to note 5 points we make about the Walmsley paper? Firstly, it is no part of any material.
Where do we find the Walmsley paper?
Of course, my lord. It's you've got 2 versions of it, my lord. The original version is unagreed bundle at tab 26, and then the final version of it, the latest version of it, is at tab 27. Okay. So we will look at it, but the 5 points I'd ask you to note, please, my lords. Firstly, it was not before any relevant decision maker, never before any relevant decision maker, and it does not represent the reasoning of any relevant decision maker. It could not, as a matter of fact, given the relevant factual circumstances and chronology. It is the thoughts of a junior officer. Just to explain, my lord, I think the respondent doesn't like me referring to Mr. Walmsley as a junior officer. By that, we don't intend any discourtesy at all. We simply mean that in the chain of command, as it were, he is either the bottom person or one of the bottom people. He's not Mr. Involson, he's not Miss Blakey. He is nowhere near a decision maker on any, we say, objective and correct analysis. The second point, my lords, is that there is no reference at all and no consideration at all in the document of the statutory guidance. The third point is that there's no consideration of the pricing and terms that would be available to the SPVs in the market at the relevant point in time. The fourth point, and this is obviously the subject of one of my grounds, is we say there is a flawed interpretation and application of the reference rate communication. And the final point, my lords, there is a deeply flawed and legally erroneous application of the 2022 subsidy regulations. So those are regulations, my lords will be familiar, used for calculating proxy values for subsidies in circumstances where you are actually giving and intending to give a subsidy. Mr. Walmsley applies that, and he thinks by applying that, it provides a conclusion that the rate on the loans is better than the market rate. That's just fundamentally misconceived. First point is that the relevant provisions of those regulations only apply to companies with credit ratings of satisfactory or better, i.e. really quite substantial companies. The SPVs are not within 100 miles of that. The second point is he actually applies the test not to the borrowers, but a different group company owned by Mr. Whittaker, who's got nothing to do, is not providing any security, no part of the transaction. And the third point is the scope and application of the regulations isn't concerned with the section 3.2 question at all. It's about proxy valuation, which is a separate legal issue. So that's what's done in the Walmsley paper, what we object to in the Walmsley paper. You see the Walmsley paper then forming the substantive basis of the authority's defence in its substantive pre-action response. Could I ask you to turn that up, please? That's the second supplemental bundle behind tab 7. And that's the letter of the 9th of May from the respondent. When you get to that, if I could ask you to read to yourself paragraph 3, where it said the authorities determined that the loans would not constitute subsidies within the meaning of section 2 of the Act. This is on the grounds that the loans would be made on a commercial market operator basis, which the authority has confirmed by reference to the interest rates set out in the 2022 regulations. So the authority's position is we've done the assessment, we haven't failed to do the assessment, we've done the assessment. The conclusion is it complies. The basis of the conclusion is the 2022 regulations. That's the authority's substantive position. Again, no witness evidence ever been provided to the court about this letter, the basis of this letter, the thought process or decision-making process. So, my lords, that really is the end of the story in relation to the decision. From our perspective, my learned friend sees it very differently, but from our perspective, that is effectively the end of the story. There is some confirmatory due diligence, but that's about property valuation. It's got nothing to do at all with the terms of the loans. Not relevant to the central issues in this case at all.
Sorry, what was the due diligence into?
The value, essentially, of the properties, my lord. So basically, are these likely to be viable investments or not? No due diligence, no advice subsequently about the commercial terms and whether they're consistent with market terms or not. Again, no dispute about that.
So there was some other delegation to the GMCA, not just to finalise the documents, but to do the due diligence.
So I think the answer to that, my lord, is that you don't get that on the face of the delegation.
No.
So frankly, probably that's something that should have been in the delegation, but it's not in the real world.
But it in fact happened.
It in fact happened.
Yeah. And had there been a problem with it, it would have been referred back to the GMCA. No doubt.
Well, yes, I certainly say that. I say under the terms of the delegation, it would have needed to have been, because the delegation was extremely limited and narrow. So I certainly say that, Lord, yes, it would have had to go back to the committee. The committee was the decision-making body, assisted with the relevant responsibilities. So on the 22nd of November, my lord, the loans are signed, and they give effect to the interest rates that were agreed by Mr. Enevoldson and Mr. Whittaker. My lords, can I then turn to my submissions, if I may? As I say, I'm going to deal with a slightly different order to my skeleton. If I can start, please, with ground 4, which is that the Cats erred in law in holding that the respondent had lawful regard to the statutory guidance. The relevant paragraph of the judgment, my lords, is paragraph 203. That's at page 148 in the core bundle behind tab 7. The tribunal found that the tribunal does not consider that in all the circumstances the GMCA had failed to have regard to the guidance. And if I could ask my lords to note the following sentence, they could have done more. In short, my lord, the tribunal immediately goes astray and fails to ask or answer the relevant legal question, was there regard? They start looking at whether they think what was done was rational or not, which is an entirely logically discrete and different question. Could I ask my lords to look, please, at the applicable legal principles? It's the House of Lords judgment in Nugee, which you'll find in the authorities bundle at tab 8. This is the leading governing case and guidance of this sort. The two paragraphs I'd ask my lords to read, if you would, to yourselves. Firstly, paragraph 21 in the judgment of Lord Bingham. So that's at page 243. Perhaps my lords could just give me an indication we've got to the end of that. Could I ask you, my lord, to look at paragraph 69, which is Lord Hope? Again, if I could ask you to read that to yourself. If I could then just distill the effect of Nugee. Firstly, the decision maker must actually, as a matter of fact, have regard to and lawfully consider the guidance. If a public authority does not do so, that is a breach of a public law duty, and the relevant decision will be, in principle, subject to being declared unlawful or quashed. Secondly, if lawful regard is had, the public authority is subject to a public law duty to comply, unless there is good reason to depart from the guidance. Thirdly, if a public authority wishes to depart, it must have formulated those good reasons clearly, logically and convincingly. Now, we respectfully submit the statutory guidance in this case comprises a significant document that creates important public law obligations pursuant to the legislative scheme which Parliament has chosen to enact.
What was the statutory
basis of unjust? I believe, my Lord, let me find it for you within the report. Bear with me one moment.
So it's page, I think it's page 236, is it? Section 118 of the
Yes.
1983.
I'm told that's correct, my Lord. Sorry, I don't have it in hand. But if it helps, my Lord, well, in my respect, especially, I mean, I have previously looked at it, that there isn't as it were, a relative point of distinction. If I could try and perhaps assist my Lord in this way, that the provisions in this case are as gold standard as one gets in terms of statutory guidance. It's statutory guidance that has to be consulted on. It's statutory guidance that's a mandatory statutory relevant consideration. This is a serious document, my Lord, is my essential submission. It's not something to be brushed aside, brushed under the carpet. I say, well, that's for entirely understandable and good reasons. The Act is at a relative high level of abstraction or generality. To have an effective regime, and this is why Parliament, in my respectful submission, has made the provision it has in Section 79, you need more detailed regulation. What Parliament has done is to confer that function on the Secretary of State. I don't know how familiar my Lords are with those principles. There are lots of authorities of this court in this territory. If it would be of assistance, we can provide those authorities. So
authorities which establish what? Sorry.
Just really the importance, my Lord, of guidance of this sort, this character, the importance is to be given by public authorities and the court in this.
Will it take any further than what we get from Munjaz?
I see Munjaz is a classic authority which you'll find other cases citing.
Thank you.
So, my Lord, our essential submission, and we say it is indisputably so, in the face of the judgment, paragraph 202, the tribunal failed to apply those principles. In the first sentence of 202, it correctly accepted that the respondent was subject to the relevant duty, but materially, it then went on and did not consider at all whether there had been compliance with the first critical element of the duty to actually have regard. Instead, it fell back on its own view that the decision and or the process was a rational decision and or process. And we say that is a classic error of law. There is no finding in the judgment that there was any regard to the statutory guidance. There could not be any such finding because all of the witness statements you have before you and all of the documents you have before you make it entirely clear that no one at any point considered or had regard to the statutory guidance. That being one of the reasons you have those materials in your bundle to enable me to make that submission. So it can't be, in my respectful submission, it can't be disputed. There was no regard. So, Lord, for those reasons, we respectfully submit that the CAT erred in law in respect of its decision on this ground of claim. And the points my Lords have been putting to me earlier, construction of section 3.2, so on and so forth, they are not relevant. This is a freestanding public law breach of duty, public law rule, subject to a no difference argument, which it would have been entirely open to the authority to take, but it didn't take, and hasn't filed a respondent's notice on the point. This ground of claim, in my respectful submission, should have been upheld, and I would invite you to allow the appeal in respect of it. My Lords, could I then turn to my grounds 5 and 6, which are concerned with the failure, we say, to lawfully apply the applicable policy, which required implementation of the reference rate communication. Could I ask you to start, my Lords, with the judgment at paragraph 198, which you'll find at page 145 behind tab 7, where the tribunal directed itself to the effect that the correct construction.
So sorry, would you be able to give me that?
Of course, I'm sorry. Paragraph 198 at page 145 behind tab 7. the tribunal directed itself to the effect that the correct construction of the language in the reference rate communication, which we briefly looked at, quote, depending on available collateral, was that it was not necessary to add 4% to the interest rate being applied to the loans in respect of the creditworthiness of the SPVs. We see that in the final sentence of paragraph 198, there is a degree of flexibility inherent in the reference in brackets to, quote, depending on available collateral. So the tribunal's reasoning, my lords, was that the words depending on available collateral provided for reducing the applicable number of basis points in respect of a borrower's creditworthiness, any reliance on the creditworthiness of the borrower's ultimate beneficial owner. And that was so even where there was no guarantee from that ultimate beneficial owner and the public authority had no information as to his liabilities or creditworthiness. My lords, could I ask you to look then at the communication again? That's Supplemental Bundle tab 1, page 5. At the top of the page, you'll see the relevant language. For borrowers that do not have a credit history or a rating based on a balance sheet approach, such as certain SPVs or startups, the base rate should be increased, I would emphasise, by at least 400 basis points, open parenthesis, depending on the available collaterals, close parenthesis. If I can ask my lord's attention to look at the matrix, you will see that what those words are doing, in my respectful submission, entirely clear and unequivocal language, are describing the effect, accurately describing the effect of the matrix, which is that if loans are being made to an SPV, at least 4% must be added to the interest rate, and that more may need to be required, depending on what, if any, collateral is being provided in support of the transaction. That's entirely clear from the matrix and the language itself. Accordingly, we respectfully submit the tribunal misconstrued the communication, or to be more precise, Mr. Walmsley misconstrued the communication, and the CAT also misconstrued the communication in its judgment. If the CAT had not erred in that manner, it would have held that the communication required the application of 3% more by reference to the borrower's creditworthiness than in fact was applied. So, my lord, we do say that the tribunal's reasons in relation to permission to appeal in respect of this ground of appeal, we do say are revealing. That's in the core bundle, tab 9 at page 162. Paragraph 18 of the reasons briefly note this ground of appeal, but the paragraphs that follow simply don't address it at all. There's just nothing there.
That submission treats the reference to borrowers that do not have a credit history or a rating based on a balance sheet approach, such as certain special purpose companies or startup companies, as being captured by the final line of the matrix, bad financial performance.
And there was no dispute before the tribunal that they are. So we say that there is no answer to this. There was an error of law in the construction of the document. So I then turn to my related submission. We say that the tribunal erred in law.
I think there's a point which is made that anyway it's aimed at least some sort of guidance or something perhaps to take into account or something like that, but it isn't mandatory.
So the reasoning of the tribunal, my lord, in my respect submission, the reason I've shown you is that they said that it authorised what Mr. Walmsley had done. I will come on to deal with that point in terms of its legal effects. I've given you the essence of my answer to that already. It was a binding public law obligation pursuant to the facility agreement and also the authority's own investment policy to correctly apply the reference rate communication. Again, that's not, I believe, disputed by the tribunal. I don't think the tribunal disputes that. What the tribunal does, in my respectful submission, it's more intellectual confusion. What the tribunal does is to say, as a matter of EU state aid law, the communication is not treated as determinative in a legal dispute about what the market rate truly is. That is conceptually an entirely different legal point, my lord. Entirely different. Here we've got a contract that says you must apply this thing correctly. Here we've got an investment policy which says you must apply this thing correctly. What happens is Mr. Walmsley, a junior officer, in my respectful submission, does not apply it correctly.
In public law terms,
Yes.
can you just deal with those 2 points in turn? What's the relevance of the contract first?
In my respectful submission, my lord, it's the foundation itself. Even if the investment policy, in my respectful submission, didn't exist, I would say in circumstances where you've got public funding emanating from central government to GMCA to be deployed for public purposes, I would say the contract is capable of founding a public law obligation to comply with the methodology which is prescribed by the contract. That's
A public law obligation owed to a third party?
Owed to a third party.
Anyone who
with
might
a,
wish to
with a
complain.
sufficient interest for the purposes of judicial review.
And even where central government isn't saying you breached our contract?
Central government, how would central government know, my lord? How would central government know? But for this case,
Well,
no
I
one...
don't know, but
No.
I think it might do, but there it is.
But for this litigation, no one would ever know what Mr. Walmsley had thought and said in his paper.
And then as to the policy,
Yes. So that's just classic public law. So the House of Lords Authority is a case called Mandalia.
but you're saying that this was part of its published policy and therefore...
Doesn't need to be a published policy, my lord. So unpublished policies, that's the Mandalia case I just mentioned.
Right.
Great binding public law obligations. But this is, I believe this is indeed published, my lord, if that helps.
I don't think there's an absolute obligation to comply with
No, of
policies,
course not. Of
because
course
that would be to fetter your own powers.
Of course.
But you have to comply with policies unless there's a good reason to depart from them.
I entirely agree with that, my lord. So at this stage of the argument, what we are complaining of is that there has been a misdirection or failure to apply the policy. We say there was never by Mr. Walmsley any decision to depart because he misconstrued the policy, or it's a question of fact. Did he misconstrue it? Did he just not really think about it? It could be either. But we say that's the legal error. There was no process here of the authority or Mr. Walmsley looking at the reference rate communication and saying the reference rate communication requires X. We say there is a good reason not to do X. We are going to do Y instead, and here's a justification for that. So
Presumably you would say that even if Mr. Walmsley, or whatever Mr. Walmsley
yes,
may or may not have thought about this, doesn't matter anyway because he's not the decision maker.
that's my grounds 1 to 3, my lords.
But does that apply here as well?
It does. It applies to all of our laws. The reason I'm taking it in this order is because I think it may be helpful for you to have seen some of the grounds to understand the structure of the grounds 1 to 3 argument. That's my thought. It may assist you, it may not. That's my thought process in doing this order.
But these are actually legally irrelevant on the main point.
On that primary case, indeed. As I say, I hope it's going to prove helpful. It may not, but the intention is that it will. Can I turn to my related point then, my lord, is that the tribunal's erred in holding that the approach adopted was a rational approach, and perhaps this is picking up from the point that my Lord Justice Nugee has just been putting to me. My primary answer to this is, as I've indicated, there was just a misdirection. There was no lawful process of departing, so the question doesn't arise. But if I have to grapple, I do have to grapple with the rationality of a decision to depart, then I say that the tribunal erred in law and how it dealt with that question. It held that it was rational to reduce the applicable margin from 4 to 1% on the ground, and it's important to emphasise this was Mr. Walmsley's ground. We'll see that the tribunal formulates different grounds, but we've got to focus on Mr. Walmsley's grounds. Mr. Walmsley's ground was that the ultimate beneficial owner is Mr. Whittaker, and there's simply an unreasoned assumption that he's to be treated as higher credit worthiness, and that's to be used for the purposes of the interest rate setting process. He did that in circumstances where first, Mr. Whittaker was providing no form of guarantee. The only covenant being provided for the loans was that of the unbacked SPVs, and the authority had conducted no due diligence or inquiry into Mr. Whittaker's liabilities or financial position, such that it had no information before it as to his creditworthiness. The Tribunal's reasoning, my lords, you will see at paragraph 199, which is at page 146, behind tab 7. And if I could ask you, please, just to take a moment to read that to yourselves. So, my lords, there are two reasons given by the Tribunal in support of its conclusion. The first you see approximately halfway down the paragraph. It's a language beginning with, given the level of collateral. I could ask you perhaps just to mark that up and note that. That's the first reason given by the Tribunal. And the second reason we find at the end of the paragraph, which is the reasoning in relation to Mr. Whittaker. The first point to ask you to note is that the first reason given by the Tribunal, the reliance on collateral and security, no part of Mr. Walmsley's reasoning at all, therefore we say irrelevant. And the second reason we say is unsupportable in circumstances where no due diligence or inquiry into Mr. Whittaker's liabilities had been conducted or into his overall financial position. See, that was not a finding which was lawfully or rationally open to the Tribunal. We say that's not a question of expertise or deference. We say, as a matter of core rationality, it cannot be rational for a public authority to lend up to £140 million of public money on the basis of someone's creditworthiness, where it has conducted no inquiry into or consideration of his liability or creditworthiness. So I entirely accept it's a rationality challenge. We say it is a good rationality challenge on the particular facts. Just to make good the point I made, my lords, that the Tribunal's first reasoning was not part of Mr. Walmsley's reasoning. Could I show you his reasons? If you could turn up in the first unagreed bundle at tab 27, page 309, you will see his reasons.
This is the unagreed bundle.
It is, my lords. It's the first unagreed bundle, and it's tab 27 at page 309.
The IRS speaking.
If my lords are on the page, it's under creditworthiness.
Sorry, which page?
It's 309, my lord. It's under the heading creditworthiness. If I could actually pick it up at the second paragraph, there is no guarantee being provided for the loans. However, in judging creditworthiness and risk, the financial position of key entities in the group, and therefore Mr. Whittaker as a sole owner, is relevant. In this direction, we say. Well, the point I'm simply making at the moment, my lords, is no part of Mr. Walmsley's reasoning is concerned with collateralisation. That's not the decision making that he was doing. It's just made up by the Tribunal.
Just so I understand, the conclusion beneath that table,
Yes,
is that based on the matrix?
based on his interpretation of the matrix.
Obviously, but
Yes,
yeah.
yes, my lord.
Yeah.
That's my understanding. Further problem with the Tribunal's first reasoning, my lords, not only is it not Mr. Walmsley's reasoning any part of that, it's also, we respectfully say, an obvious misdirection. You've looked at the matrix. There are two distinct ingredients. One is creditworthiness of the borrower, the other is collateralisation. The collateralisation point has already been taken into account. You don't double count it when you're dealing with the separate question about creditworthiness. Could I draw your attention, my lords, to the final sentence of the relevant paragraph in the Tribunal's judgment? It said there was a residual, although most probably unlikely, risk that he had large liabilities which could have been wiped out these funds. As equity had been placed at the time of drawdown, the authority had substantial protection against the consequences of such an eventuality. We do say with great respect, my lords, that that is an unsupportable finding. The proposition that it is an unlikely risk is a proposition for which there was and could be no evidence, because no due diligence had ever been conducted and there was no consideration of those issues. It is simply making an assumption.
What have these funds been referred to?
So I think what's been referred to there, my lord, I think, I'm speculating, I think it's basically just talking about the loans, I think.
Isn't it talking about the distributions in the liquidation of XQ developments?
My lord might be right, yes. Yes, I think actually reading it, I think my lord's right about that.
Which had a net assets of 321 million.
Yes.
And isn't the point about equity being made that it was a condition of drawdown
Yes.
that Mr. Whittaker had to have put in?
Yes, that's the point.
So they're saying, as I read the last sentence, they're saying actually the risk doesn't really matter because the funds would never be drawn down unless he had actually put them in.
So, my lords, there are two, I think there are two separate points, my lord, in what you just put to me. So the first point is about the distribution from a liquidated company.
Yeah.
That's a discrete point. The answer to that point, my lord, is there's no dispute that that releases a large sum of money. There's no dispute about that. The point is individuals who operate at the level of large sums of money tend to have both assets and liabilities measured in large sums. So in my respectful submission, if the suggestion is, well, we know that there's a large pot of cash that comes from that liquidation, that's not, in my respectful submission, a supportable position, because one can't assume that the liabilities are not comparable or indeed greater. It needs to be looked at. That's my first point. Second point, my lord, just put to me as a different point. It's about equity injection before drawdown. Absolutely, my lord, that is a term of the lending arrangements, and we take no point in relation to that. That is an absolutely standard feature of any transaction of this sort, that you require the equity to go in before the debt. That is no panacea, my lord. These are 3-year loans. Equity goes in on day one. One uses equity to build the building. As a lender, you're then exposed for 3 years to the credit risk on the borrower. The money from the equity is used to build the partially built building. If something goes wrong, you as a public body then have a partially built skyscraper in Manchester, which you cannot complete. And you're going to have great difficulty negotiating with a new property developer to come into a partially built building to complete. So the notion that equity going in on day one is some sort of answer to the risks of this transaction, in my respectful submission, that's unreal.
Why do you say which you could not complete? I mean, normally if you're a lender and you lend on a development project and the borrower goes bust, you have step-in rights and you produce receivers and they complete and recover your money.
Well, that's what you try and do, my lord. If you're I say this with some experience, if you're a public authority tasked with seeking to complete a skyscraper, a high-rise skyscraper in central Manchester, that is going to be an extremely uncomfortable situation. And if one stands back, my lord, and thinks about what are the circumstances that are going to lead us to the position where the developer isn't able to complete, inherently likely it's going to be something that's problematic with the market. You as the authority are then stepping in to that problematic position. So, my lord, I'm not intending to say that there isn't legal recourse here and that these arrangements aren't of some value. They obviously are, that's why they're standard features of these transactions. The point I'm simply making is the notion that equity going in as a precondition to draw down of a debt facility is some sort of, let's say, panacea or complete answer to transaction risk. I find that it'll be a matter for the court. I find a very surprising proposition.
I don't think they were saying that, but
well,
I think you were overstating what the cat said. I think they're saying it's part of the package.
I may be putting it. I'm trying to deal with the point, my Lord. I may be overstating. I accept that.
Thank you.
So, my Lords, for those reasons, we do say that the cat also erred on that aspect of its reasoning. We would invite you to allow the appeal. My Lords, could I then turn to my grounds 1 to 3, which I will take together because they do significantly overlap in my respectful submission. So, my Lord, firstly, and the core submission is that the tribunal erred in law by failing lawfully to consider and decide whether in making the decision based on the information and advice before it on the 22nd of March, the GMC committee complied with its statutory and public law obligations. And the core proposition, my Lords, is we say that that approach, failure by the tribunal, was contrary both to Section 70 of the Act and also, we say, well-established binding appellate authority. The errors of law, my Lord, we say they run through the entirety of the CAT's operative reasoning, but are clearly encapsulated, we respectfully say, at paragraph 153, which you'll see on page 131. And if I could ask my Lords to just take a moment to remind yourself of that. This is the CAT's self-direction. We do say, my Lords, it is entirely plain and stark. We are not going to do what Section 70 requires, what case law requires. We are going to look not at the decision or what was before the decision maker. We're looking in the round at this entire process. And we say that this forms no part of the applicable legal principles.
So what's the error here? That they seem to be saying they're going to look at things beyond the date of the decision. Is that your complaint about this? Or is it your complaint that they're going to make the decision themselves?
It's the first point, my Lord. Quote, we need to consider the whole process, including the various stages leading up to the decision, as well as subsequent stages. We say there's no mystery about what's going on. The CAT considers this as the lawful approach. We say it's not the lawful approach. We see that worked out in the judgment then, my Lords. If I could show you, please, a number of paragraphs. Firstly, if you turn to 144, page 144 within the judgment, starting at paragraph 195, you will see the heading. I could ask my Lords to highlight the heading. Did the analysis in the IRSP fail to comply with the reference rate communication? So that's referring to Mr. Walmsley's analysis. The self-direction, the legal question the tribunal is asking itself is, did Mr. Walmsley's analysis fail to comply with the reference rate communication? That wasn't the legally relevant question. So the decision-making that mattered, not Mr. Walmsley, with all due respect to him. If the Lords could look at paragraph 198 in the second sentence.
Say there's anything wrong with the question at 184D.
180.
4D.
Could I come back to that one moment, my Lord? Could I just give you the references that I wish to give you, and I'll put that up if I may. Find that for you, please. Next reference, if I could, 198, second sentence. The IRSP, i.e. Mr. Walmsley, was right to consider this communication and was entitled to do so without being strictly bound to follow it blindly. That's, I think, the point one of my Lords was putting to me earlier. It's got several component parts. Firstly, misdirection. Mr. Walmsley, it's the decision maker that one should be referring to, says that he did need to consider the communication, but he wasn't bound to follow it strictly, and I've explained why I say that's not correct. Then 199, fourth sentence, Mr. Walmsley was entitled to take review, but it was not necessary or required for 4% to be added to the base rate as a minimum.
Sorry, where is it?
That's 199, fourth sentence, my lord.
Yes.
And then the entirety of the substance of 190 to 192, there the tribunal's basing its decision on Mr. Walmsley's thoughts in the Walmsley paper. Most clear perhaps at 190 in the final sentence. The IRSP reflects a careful consideration of the various factors to be taken into account. So it seems it's accepted that these are all mandatory considerations. What's being said is it's good enough if Mr. Walmsley has thought about it, and we say that's the fundamental misdirection of legal error. So, my lord, you asked me if I had a problem with the formulation at paragraph 184, little d.
Yeah.
So I have no problem with it as a formulation of the relevant legal test that arises under section 3.2. My position is that, as a matter of correct construction of the Act, it is not the tribunal's job at all to simply decide that question for itself. It is the function, as I sought to explain earlier, of the public authority to take a lawful public law decision in respect of that, which the tribunal will then review on well-established public law grounds on the substance rationality. So, Lords, we see this approach is
That I think is subject to the point you made earlier. If it had been said, well, even if the authority didn't go through the right process, the inevitable
no
result
difference. Indeed.
would have been that it...
Absolutely,
Yes.
absolutely. I don't dispute that, my lord. I can't dispute that. That's how public law works.
Yes. But you say that wasn't a point that was taken, there's no respondent's notice.
There aren't any findings about it because the point was never taken. So, my lords, we see this as a fundamental error of law. I won't repeat the points. I've made the points already about facts. These are Mr. Walmsley's thoughts. The paper as common ground was never placed before any relevant decision maker. That's stated lucidly in my learned friend's appeal skeleton, paragraph 28 at the first sentence. That's core bundle, tab 5, page 54 for your reference. And it was also made clear before the tribunal. That's the supplemental bundle, second supplemental bundle, tab 9, page 49. It's within the transcript, internal page 179, lines 20 to 23. So, my lord, the authorities establishing that this is indeed an error of law, if I could quickly show you those. The first case is the Court of Appeal Authority, the Stratford case. Could I ask you to turn that up, please? It's Authorities, tab 10. The report begins at page 301. So we see the decision in Stratford was a decision about wheelchairs and black cabs. The decision was subject to detailed consideration by the Authorities General Purposes Committee. You see that in paras 4 and 5. However, the responsible decision maker was the Cabinet, not the GPC. When the Cabinet considered the decision and decided to approve it, it was not provided with, and therefore did not lawfully consider any adequate summary or account of the legally required relevant considerations. That's paragraph 11. And if I could ask you, please, to read 10 and 11 to yourself. Emphasise in particular the final paragraph under paragraph 11. The fundamental public law principle is it is the decision maker who must address the legally required matters. It is not sufficient, indeed it is irrelevant, if some other person or body considers the legally required matters either before or after the decision that's subject to challenge. And we see that in stark terms in Stratford. That is so even if the other person is a very senior decision-making body within the authority. If it's not the decision-maker, that is not good enough. You ask the Lords also then to look at the Kenyan Authority, which is another Court of Appeal authority, which you'll find behind tab 13 at page 386. Authority sought to defend the decision relying on both documents containing reasoning produced by officers after the date of the relevant decision, also documents produced by officers before the relevant decision but had not been considered by the relevant decision-making body. The operative reasoning, my lords, you'll find in the report at page number 401. That's the pagination. And it's paragraphs 28 to 30. And if I could ask you, please, to just read 28 to 30 for yourselves. So those authorities...
Just so we can anchor these decisions, these cases, the decision that was to be made by the decision-making body in those cases, in each case was what? What was the precise decision?
Precise decision. So, my lord, in relation to Stratford, it was the approval of a new policy, the policy about how black cabs would be required to deal with taxis.
Yeah.
And in Kenyan, and I'll check this, I'll come back to you after lunch, but I'm pretty certain it's a decision about an environmental impact analysis.
So they're quintessentially policy decisions that the court could never make. The decision always has to be made by the local.
Well, no, my lord, not at all, with great respect. Those sorts of decisions are absolutely routinely challenged by way of judicial review.
No, I understand they're challenged,
yes.
but the decision maker always remains the council.
Absolutely.
Or the authority.
The primary decision maker is always the public body. It's then subject to review by
yes.
by the court.
But they're a decision of a different nature than the question here, which as we debated earlier, it's a legal question, which the court would be as well equipped to determine as the authority. You may say there are disadvantages with that.
Yes.
It's as well equipped to make that sort of decision.
So I would respectfully submit, not my lord. I'll come on to show you the authorities. What the authorities, and this is true of state aid law and domestic law, what the authorities say, in my respectful submission very clearly, is that the court is not as well equipped to make these sorts of decisions as the responsible public authority officers. These are people who are, or certainly are supposed to be, steeped in their relevant function with years of experience. And they're supposed to have a knowledge, for example, of the relevant market that they're operating in that is positively different, and with great respect to all of you and us, superior to a judge who has spent his life in Temple. You will see this in the authorities. This isn't just where my view. The authorities do say that. So if my lord's putting to the proposition on the question of assessing the commerciality of a property transaction, is the judge better placed or as well placed to make that assessment as a responsible public authority? I would respectfully say the judge is not.
It was a point that was made by Lord Justice Nugee several hours ago, which is that the CAT is a specialist tribunal
yes.
with access to
yes.
the expertise and
yes.
knowledge of, including in
yes.
this case, people with banking experience.
Yes.
So they're not quite people who've grown up in the Temple.
I entirely follow the point my lord's putting to me, and I also, I think I'm bound to accept there is some force in that point. What I say about that, my lord, several points, if I may. The first point is, I do say, quite right, my lord puts to me, there were two gentlemen with banking experience in this case. I do say, my lord, the legal system, the legal framework has to cope with all sorts of different cases and different contexts. I do say it won't be possible to have, as it were, two bankers all the time. There will be cases about subsidies that come up which are not cases about loans. There'll be cases about all sorts of different arrangements. So my respectful submission, one can't or shouldn't lean too much on the fact here we were able to get two distinguished gentlemen who had that relevant experience. I do accept the point I think my Lord's putting to me, which is, well, the CAT's a specialist body, isn't that potentially of some relevance? I follow that point. I say it's not an answer to the fundamental point I'm making, including by reference to well-established authority. Very well-established authority. Principal decision makers under our constitutional system, absent very clear statutory words, principal decision maker is the public authority when discharging public functions. Court is reviewing.
These are cases where the statute itself says that the body shall make a decision. It's a planning decision in this case.
So, I don't think it will be as clear cut as that, Lord. I think I haven't checked. I'll check that if it's resistance. It might be the case in relation to the planning decision. I don't know. It certainly wouldn't, I would expect, be the case on the policy. So that will just be, if like, general discharge of function. But my lords, if I could, perhaps I understand the point I think you're putting to me. Is there a relevant distinction? No, there's not. And again, we can give you lots of authorities about this if you want. These authorities I'm showing you are applied day in, day out across all levels and types of public authority decision making. It's public law 101, if I could put it in those terms. Public law is about decision makers. Again, forgive me, this is incredibly trite stuff, but I can show you lots of judgments which deprecate exactly the exercise that's conducted here, some sort of, well, let's just look at the whole process, let's have a look around and see what's going on. That is not how a judicial review jurisdiction works. Judicial review is about challenges to decisions. And the absolutely critical first step to proper legal analysis is, what is the decision that I'm reviewing and what is the material on which that decision was made? If we lose sight of that, frankly, the system rather breaks down. So, my lords, these authorities were addressed orally, also in the skeleton argument. That's one of the reasons, again, you've got the skeleton argument. That's unagreed bundle, tab 4, page 65, at paragraphs 54 to 55. The authorities are simply not dealt with at all in the judgment. The tribunal's reasons for refusing permission to appeal, you can see those behind tab 9 at page 160. Its response as a matter of law was to seek to distinguish those authorities on the basis they were concerned with, I quote, ex post facto attempts to rely upon evidence that was not before the relevant decision maker. By contrast, the tribunal explained that it would not look simply at the terms of the GMCA committee decision. Two, we say, very straightforward answers to that. Firstly, as I've explained to you, Kenyon and Stratford aren't merely concerned with ex post facto reasoning. They're also concerned with circumstances where someone considers matters before it comes to the decision maker, but material doesn't make its way to the decision maker. The tribunal doesn't appear to have understood the judgments. And the second point is, its suggested distinction is not a distinction at all. Its point of distinction is, we've directed ourselves that we're going to do what has been said to be wrong in those cases. So, my lords, we say for those reasons there is a clear misdirection and a breach of public law duty in the tribunal's approach. We say that does require the judgment to be overturned. My learned friend has his points, and the tribunal's put a number of the points to me about what is the correct construction of section 3.2. Is it an objective test on the one hand? Is it the court reviewing a primary decision of the public authority on the other hand? Those are relevant questions which I'm going to come on to address for what I would characterise as the outcome rationality challenge, the attack to the compliance of the rates with section 3.2. They are just not an answer to the separate public law wrongs that I've been dealing with in my other grounds. Failure to have regard to the guidance, failure to lawfully apply the policy. They are analytically, logically separate and discrete issues. So
I just understand that submission. Are you saying that the answers that are given are bad, or are you saying you never get into those?
You don't get into those, my lord. You don't get into those. they're not legally relevant. So sorry, I'm not being clear. Forgive me. Let me try and, if I can explain the point as clear as I can, because it's an important part of my submissions. In this case, there is a complaint that there was a failure to have regard to the guidance, and obviously my Lord will take a view about that. There is also a complaint that the outturn of the rates, the outcome of the decision, was non-compliant with Section 3.2. Those are logically discrete and separate public law complaints. There are lots of points being made about what is the correct approach to adjudicating on the Section 3.2 outcome complaint. I say the correct analytical framework is the primary decision is for the public body, and the court reviews that on rationality grounds, standard public law analysis. My learned friend disputes that. He says the tribunal simply decides that question for itself. He says pursuant to EU state aid law. I'm going to come on to seek to deal with that and explain why I say that's not correct with respect. So two competing analytical frameworks, I hope that makes sense. Even if he's right about that on Section 3.2, it doesn't affect whether there was or wasn't a lawful regard given to the statutory guidance. It's a separate complaint.
You say there are two separate complaints. You don't make those two separate complaints, do you? Your complaint is process-driven, isn't it?
I think it's right to say, my Lord, that certainly the primary focus of my case is process-driven. I think.
But it's not a ground of appeal, is it, that the CAT was wrong to say that this complied with 3.2?
So I think it's the logic. Can I think about that, my Lord? Because I don't want.
Well, you do say that they shouldn't have considered it.
So I say, could I think about that? Just make sure I give you a correct answer to that after lunch. I think my instinctive reaction is it's a consequence of my grounds 1 to 3 that would be or might be the conclusion that one would reach because there hasn't been a lawful analysis. But I think my Lord's putting to me that I don't have, as it were, a straight up outcome rationality challenge. I think that is quite right if that's the point you're putting to me.
Well, just so I put it in my language,
Yes,
you're not challenging the CAT's. You say the CAT shouldn't have determined the question of whether this was compliant with 3.2, but you don't say, if you're wrong about that, their conclusion was itself wrong. I
say, well, I do have a point in relation to that, my Lord. I say, I'm sorry, forgive me. Could I think about that after lunch and come back to you? I want to make sure I get that right with answer. So, my Lord, turning.
I think these points you've just been making are quite central to the nature of the exercise that we're engaged in. I didn't manage to write it all down. I would find it helpful if you reformulated that after lunch in a way that I could actually get down.
Shall I try now, my Lord? Because we've got 5 minutes, so I think that might be
we'll do it.
sensible.
So what I've understood is you say it's for the decision-making body, the authority, to decide, having regard to the statutory guidance, etc., to decide whether the financial assistance in this case is a subsidy or not.
Yes.
That depends upon whether other people in the market would have provided similar terms to these SPVs, and they never went through that exercise.
Yes.
And you say that's the end of the question.
Yes, I did. That's my simple submission. That's my simple stage 1 submission.
And if one accepts that, then subject to the Section 31.2 point, which isn't run, then that's the end of the case. And the decision that was made, the March decision, has to be quashed, or at any rate, it has to go back to the CAT to find out what. But at any rate, we should allow the appeal and say that was not lawfully made.
That's my simple submission.
That's your simple submission. Now that does not involve us forming any view as to whether actually these rates were commercially available or not.
Yes. So, my Lord, that's absolutely my case. And what my Lord's just outlined, again, I'm going to be repeating myself, but that is standard public law 101 orthodoxy. Almost every judicial review of these courts is about the decision-making process.
Yes, but it involves, as a first step, us accepting the submissions which you started off with this morning, but it was for the local authority to decide.
But there was some public law obligation
to decide if it's a subsidy or not, and that they had to do it in a particular way.
Or to consider, my Lord, yes. So absolutely, it's an essential predicate to what I'm saying, that there is some sort of public law obligation to engage in some sort of process of consideration. That's one of the reasons I've structured the submissions in the way that I have, because I wanted you to see what I say about the sources of those obligations.
And you then went on to say, to characterise Mr. Robertson's submission, which was that it was for the tribunal, for the CAT,
yes,
to decide
yes,
if this involved a subsidy.
yes.
They did make that decision,
Yes.
and unless that is...
Yes, unless you can knock that down.
Unless you can knock that down,
rest
that's
of
an end of the case, because if it's not a subsidy,
That's
the Act doesn't apply.
well, no. So that's not his submission. If I could say, my lord, that last part. That's not part of the case that was run before. The way it's put is, and this is the way, frankly, it's put in the judgment. Breaches of process don't matter if we, exercising this jurisdiction to decide the question objectively, have concluded that it's not a subsidy.
But that is because if it's not a subsidy, none of the obligations in the Act, the subsidy control principles, the obligation to put it in the
Yes.
register, and so on and so on, none of them.
So that's not what the tribunal has reasoned or found. That, if I may say so, is my lord's point that you've raised with me, I think, earlier in this hearing. That is not the tribunal's reasoning.
Right.
The tribunal's reasoning is simply, it does not analyse separately or discretely the relevant public law grounds of claim that I've been addressing this morning. It says, and you'll see this with great respect to the tribunal when you read the judgment, it collapses everything to the single question. Objectively, do we think there's compliance with Section 3(2)?
Yes.
We think there is. We think that's the only question. They think the separate freestanding public law complaints only relevance is in informing that analysis.
Yes.
It's not. They can be relevant for informing the analysis in my respectful submission. Problems in process can inform what you think about outcome, but they're also freestanding public law grounds of complaint. And my lords obviously put that point to me about, well, the jurisdictional position under the Act, how does that operate? I hope that makes sense.
Thank you. Is that
But do you say, I'm sorry,
Not at all.
if I may, just to understand the structure of
Yes.
this, you say that, as I understand it, that it wouldn't be a complete answer to say, objectively, it's not a subsidy, because you say that that there's a positive obligation on the
Yes.
public authority to address its mind to that question, and in doing so, follow the guidance.
Yes. Logically prior question, my lord. I do say that is basic public law principle.
But what's the consequence? It seems a rather paradoxical consequence if
So it's only a paradoxical consequence, my lord, if my learned friend's analytical analysis of how the Act operates is accepted. I say it's one of the strong indications that that framework is not the correct interpretation of the Act. In my learned friend's case, the Subsidy Control Act is going to operate in a radically different way to all other areas of public law. That's why I sought, in the course of showing the statute and the guidance, I sought to explain what I say is the correct distillation of the framework. If my submissions are correct, this operates in the same way, with some minor adjustments, as every other area of public law review. If I'm not correct, then in respect of this Act, notwithstanding that in Section 70, Parliament has said in the clearest possible terms this is a judicial review jurisdiction, in effect, it's not really a judicial review jurisdiction, it's the CAT acting as the decision maker, objective decision maker, if the case against me is correct. And I do say, for a whole number of reasons, that's not what the statutory words in Section 70 say, and it would be surprising and disharmonious with our general legal
But
principles.
you could have an Act, and we'll have to decide
Yes.
if this is what which divides the world into. If it's a subsidy,
Yeah.
then you have to apply the subsidy control principles, and
Yes.
that's subject to judicial review, and,
Yes.
and so on and so forth. But if it's not a subsidy, you don't get into it at all.
Yes.
And that question, is it a subsidy or not, is a justiciable question rather than just a public law question. And I think that's really the argument you're facing. I may have misunderstood it, but
I'm not sure I understand that, my Lord. I'm not sure I understand that proposition as you just put it to me, which I'm no doubt is my failing.
So on this view, it's for the CAT to decide whether it is a subsidy or not. If it is a subsidy, then you get into all the judicial review principles and so on and so forth. But if it's not a subsidy, then there's nothing to see here.
So, my Lord, that's the point you put to me on a number of occasions.
But I may have misunderstood, but I thought that was the case you're facing.
So it's not. If I may say so, my Lord's analysis is more sophisticated than the Tribunal's analysis, if I could put it in those terms. You will not find, if I may say, you will not. You may have detected it. I don't believe it's in the Tribunal's judgment. I don't think you will find that thought process. But my Lord, if I could try and deal with that, just again head on. I've shown you section 79 2A already. The Act is specifically saying that the Secretary of State can issue statutory guidance which will have the...
And that will include whether it's a subsidy or not.
It's the prior statement, it's the prior question.
Yes, I think I understand quite clearly your case.
Yes.
Yes.
And I'm going to deal, after lunch, I'm coming on to deal with why I say the analytical framework that the Tribunal did apply, which is reliance essentially on EU state aid law, if I use that as shorthand, is not the correct legal approach. I'm going to seek to make that good after lunch.
Thank you very much. We'll say 2:05.
Thank you very much.
So, rise is able.